Adam Keith.
Yes, madam.
All right, just stand there.
Stand right there.
Bridget, your client is here.
Okay, give me 2 seconds, Judge.
All right. And are there any applications?
No, Your Honor.
No. Okay,
All right, the court is calling 2025 CR 003783 State versus Adam Keith. Can I have parties announced?
Ashley Jones for the state.
Bridget Garza for defense.
And are you Mr. Keith?
Yes, ma'am.
All right, do you have any objection to your attorney appearing by Zoom?
No.
Counsel, have you received all discovery? Did you review it with your client?
I have, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Keith, did you review the true bill of indictment with your attorney? Did you understand it?
Yes.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
We are not, Your Honor. We are going to proceed on count 2, paragraph B, waive the other counts in paragraph, and we will also waive the repeat offender enhancement allegation.
We have no
objection?
objections, Your Honor.
All right, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
No.
And I'm so sorry, you said you're proceeding on paragraph B of count 2?
Yes, Your Honor.
All right, did you understand in count 2, paragraph B, you're charged with sexual assault? That is a second-degree felony. Range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine. If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
No.
Did you understand by entering this plea you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea in this case? Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Keith, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, the state is proceeding on count 2, paragraph B, waiving all other counts in the enhancement. Punishment is to be assessed at 3 years in the prison. There's a $1,500 fine. There's no application. There's an affirmative finding of family violence, Chapter 62 registration, and it's a lifetime registration, and there's to be no contact with the complainant. Did you understand that to be the plea?
Yes, ma'am.
Defense?
Yes, Your Honor.
State?
Yes, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it? Did you sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, are there any such motions?
No, Your Honor.
Then to the offense in count 2, paragraph B, how do you plead? Guilty, not guilty, or no contest?
No contest.
All right. And just one other thing. Did you understand with an affirmative finding of family violence, you're not allowed to be designated as primary custodial parent?
Yes, ma'am.
And did you understand with an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition?
Yes, ma'am.
Knowing that, do you still wish to continue with the plea?
Yes, ma'am.
All right, State, do you have any evidence to support the defendant's plea?
State would offer State's Exhibit 1 and all attachments.
Any objections?
We have no objections, Your Honor.
All right, and State, have you spoken with the complainant?
We have, Your Honor, in the past, and we've attempted contact recently.
All right, thank you, State. You may be excused. Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call in the right to remain silent? Did you understand that today the state would be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there will be no live testimony. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. All right, now I understand why the offer is as it is. The court will find that there's sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing, counsel?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Your Honor, we're asking the court to follow the recommendation of the ADA and sentence him to the 3 years TDC and give him credit for time served.
All right. Then the court is finding you guilty as previously stated. The court will sentence you to a $1,500 fine, 3 years in the prison, give you credit for any time served. There's to be no contact with the complainant. There's to be Chapter 62 registration.
This is where the courtroom air thins. 3 years TDCJ, $2,500, lifetime registration, and a formal wall between defendant and complainant. Notice how Judge Boyd triple checks the rights waiver and competence questions. That's not small talk. It's appellate armor. Also clock the family violence finding. It's not just stigma. It legally nukes future firearm rights and even primary custody eligibility. The no contest plea, NOLO, still lands a conviction for purposes of collateral consequences. Here's the moral pinch. Plea deals compress complex stories into tidy packages, efficient for dockets, brutal for futures. Question for you. Should lifetime labels be tied to a negotiated plea, or only after a jury's full airing of facts?
And there's an affirmative finding of family violence. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it?
Yes, ma'am.
And did you sign it?
Yes, ma'am.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction and also an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, we can go off the record. Here's the thing. You can't be drinking alcohol because obviously you're one of those persons who cannot drink, right?
Yes, ma'am.
If you would like, I can recommend the therapeutic community for you at the prison. They may not place you in it due to the nature of your offense, but it's to help you with sobriety and other issues you may have. I can't order them to place you in the program, but I can let the judgment reflect that I think it would be best if you were in the program. It doesn't increase the length of time that you're in custody. Do you understand?
Yes, ma'am.
Would you like for the court to do that? All right. All right. Good luck to you, sir. You're welcome. All right. Counsel, you may be excused.
Thank you, Judge. See you
You're
later.
welcome. All
Bye-bye.
right. Good morning or afternoon, I should say.
How you doing?
All right. How are you doing?
Doing all right.
There are applications in this case?
Yes, there is, Your Honor.
Is there a restitution amount?
There is. There is an agreed restitution.
All right. And what's the agreed restitution amount?
$5,000, Your Honor.
And are you going to be able to pay the 5,000?
No, but I'm gonna have to look for a job pretty soon.
How old are you?
19.
All right. Is there any chance that he's going to be able to pay this?
I looked into it, Judge,
Mhm.
and it's, there is also, after you read it, there is a weapon involved and also drugs involved. And also just because of the nature of the actual crime, it seems that it might have been a repetitive behavior.
All
Not
right.
that he has anything in his past, but that's the reason I've decided to go with this.
Oh, no. He's going to have to pay restitution. I'm just figuring out when is he going to pay it?
Sure, I think he can. I don't think if today he has to pay it. I think that's what he's answering. No, he can't do it today. But I think given the course of deferred, I think he can.
All right. So when will you be able to pay at least $1,200?
I can see if I can get some money together pretty soon, probably next week.
All right. Are you staying with your parents or
Just my mom.
your mom? And your mom's employed?
Yes, ma'am.
What does she do?
She works for the Texas Lottery Commission.
Okay.
So
Why am I not winning anything? I try.
I think it's designed that way, Your Honor.
Well, no, honestly, I will tell you, when I first came to Texas in 1994 for law school, I actually did a scratch off, super broke. And I'm like, thank you, God, I won $500. And guess what ends up happening? Do you know you couldn't go to the gas station to get $500? And I'm like, I don't have a vehicle. I can't get to Austin, take a bus to Austin, then try to find it. The only people who would pay you money for up to $500 was Albertsons. And then I had to find somebody. Does anybody know where Albertson is? And it was like law students. They're like, oh, we'll drive you to Albertson. Ooh, that $500. I was the wealthiest person for about, I don't know, a month. All right, because lunch was expensive on campus.
Mhm.
But the guy who worked there was always nice to me. He would let me pay him installments. So all I would eat every day was one meal, and that would be a Philly cheesesteak sandwich.
Those were good. Okay.
Oh, they were
Those
so
really
good.
Yeah, I remember.
Yeah. All right, court is calling 2025 CR 007442, State versus Ezra Espinoza. Can I have parties announced?
Jason Gary here for the state, Your Honor.
Patrick Laws for the defense.
And are you Ezra Espinoza?
Yes, Your Honor.
Counsel, have you received all discovery? Did you review it with your client?
I have, Your Honor.
Court will find that the state is in compliance with discovery. Did you review the application for deferred adjudication with your attorney? Did you understand it and sign it?
Yes, Your Honor.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes, Your Honor.
Counsel, do you waive the reading of the indictment?
We do, Your Honor.
State, are you proceeding on the indictment as presented?
We are, Your Honor.
Did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes.
All right, you're charged with theft of property, $2,500 to $30,000. That's a state jail felony. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. If you have a plea with the state, court does not have to follow your plea. If I don't follow your plea and give you more than you all have agreed upon, you can withdraw your plea, start over, or go to trial, and it cannot be used against you. Do you understand?
Yes, Your Honor.
You have a right to a jury trial. Do you understand what a jury trial is?
Yes, Your Honor.
By entering this plea, you're giving up the right to a jury trial, you're giving up the right to remain silent, and you're giving up the right to have your attorney question any witnesses. Do you understand?
Yes, Your Honor.
Is that what you want to do?
Yes.
Did you understand that the court grants your application for deferred adjudication if for any reason a motion to revoke is filed against you? And if you are revoked, I could sentence you up to 2 years in the state jail facility and up to a $10,000 fine?
Yes, Your Honor.
All right, do you understand that state jail felony time is day for day? There's no 2 for 1 or 3 for 1. Do you understand that? Counsel, has your client been able to provide you with any defenses?
He has.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, ma'am.
Mr. Espinoza, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, Your Honor.
Anyone promised you anything other than what your plea bargain is?
No, Your Honor.
Are you satisfied with the way you've been represented?
Yes, Your Honor.
Are you a U.S. citizen?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, Your Honor.
All right, according to the plea, there's a $2,000 fine. State is recommending you receive deferred adjudication. This is going to run concurrent with 2024 CC 736745. There's to be restitution, and it's agreed upon, to Clara Valle of $5,000. Did you understand?
Yes, Your Honor.
Is that the plea defense?
It is, Your Honor.
State?
It is, Your Honor.
Did you review that waiver of appeal paragraph with your attorney? Did you understand it?
Yes, Your Honor.
Did you sign it in both places?
Yes, Your Honor.
By signing that, you're giving up your right to appeal. That means that you can't complain about anything unless your attorney has filed some sort of pretrial motions, and I've made a ruling of those on those. Do you understand?
Yes, Your Honor.
Has there been any such motions?
No, Your Honor.
So you will not have a right to appeal. Do you understand?
I understand.
Outside the agreement, the state is recommending that your community supervision be for a term of 2 years, that there be a TAP evaluation, 160 hours of community service restitution. What that means is you go somewhere and you work for free. And if it's 160 hours, that means you have to work 160 hours. Do you understand?
I understand, Your Honor.
And there's to be no contact with Clara Valle. Did you understand?
Yes, Your Honor.
Now, what the state is asking for there, that's not a part of your plea bargain agreement. I don't have to follow it. Do you understand?
I understand.
Right, then to the offense, how do you plead? Guilty, not guilty, or no contest?
No contest.
State, any evidence?
Yes, Your Honor. State Exhibit number 1 with all of its attachments.
We have no objection, Your Honor.
All right, did you review the stipulations with your attorney?
Yes, Your Honor.
All right, the stipulations have the police reports in it. It's supposed to have all of the documentation that the state needs in order to prove to me beyond a reasonable doubt that you committed this offense. Do you understand?
I understand, Your Honor.
So again, state is not going to call any witnesses. Their witnesses are in the form of the documents in this paperwork. Do you understand?
Yes, Your Honor.
You're giving up the right to remain silent. So what does that mean? I can ask you questions. The state can ask you questions. Do you understand?
Yes, Your Honor.
And there's not going to be anybody called for your attorney to question unless your attorney decides to call someone. Do you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and submitted to stipulation of testimony and stipulations. Court will accept into evidence States Exhibits 1 and attachments and review the same. Here in States Exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. Court will defer finding of guilt as you've applied for deferred adjudication. All right. We can go off the record. This is what I want to know. The restitution is $5,000. That person wants their $5,000. I understand sometimes people will come before me and they're like, I don't have $5,000. And I'm like, you should have thought about that before you did this. So you're not employed. Your mom is trying to work. And how many siblings do you have?
5, but they don't live with me.
They don't live at home. So it's only you and your mom? Does your mom have a mortgage?
I believe so.
All right. And she has a car note?
Yes.
And she has insurance to pay for that? You're not working, so she pays for you to live, right? She has to pay for you to have food, pay for your clothing and everything. Am I right?
You're right.
This is classic Judge Boyd. Part judge, part mentor, part economic reality check. Restitution isn't a suggestion. It's a victim's ledger the court intends to balance. Legally, restitution aims to make the victim whole, but practically it becomes a compliance test. Work, pay, or come back with excuses. The judge's don't borrow for court warning is smarter than it sounds. Debt chains become pressure cookers that trigger violations. And the GED push? It's not moralizing. It's about earning capacity, the only sustainable way to satisfy court-ordered money without spiraling. You decide, is forced financial accountability justice, or just shifting harm from the system to already strapped families? Drop your take below.
All right. Did you graduate from high school?
No, I did not.
Why not?
I don't know, I never went. I went, but I just never stayed. You know, they ended up kicking me out.
All right. So here's my question for you. Do you love your mom?
Yes, I did.
Do you care about her? It doesn't seem that you do. And let me just tell you why.
Why?
She's working hard and she's supporting you, putting a roof over your head, paying for your clothes. And I'm sure all she has, her expectations of you, is probably the same expectations my mom had of me and my siblings was go to school. And you know, my mom would always say, you know what, after you get out of school, you can run around and play a little bit, because for her school, she's like, that's sort of like a job, because you're there at the beginning of the day and then all through days, and then you're dealing with different personalities. So your mom is doing all of that for you, and you're not doing anything except this, getting in trouble. And I already know what's going to end up happening with this $5,000. His mom is going to probably end up having to pay for it.
Well, I will say he didn't put it on the application, but he is doing part-time work. It's not really steady work, but he is working.
All right. So, and how far did you go in school?
To 9th grade.
All right. He can't do much with that. And I can tell you right now, I'm not allowing you to work as a home health care provider, and they're just out here hiring anybody. Not all places, but some of them. So you're going to have to get employment. You need to pay this, not your mom.
I will.
So I'm going to reset this. So when can you come in to this court with $1,000?
Probably next week.
Okay, here's the thing. Don't do that next week because when you come in with $1,000, it has to be from legitimate sources. It can't be you doing whatever you do to make extra money. It has to be legal work, and it can't be you calling around all your relatives or friends asking them to borrow money, because when you ask them to borrow money, when the payment becomes due for them on that, it's going to cause you stress and it's going to be hectic and you're going to start ducking and dodging them. So, do you want to talk to your attorney about when you can actually come to this court with $1,000?
I mean, I have a little bit of money saved, so would that be good, or
How
would
much
I-
money do you have saved?
like 800?
All right. So, when can you get the other two?
Do not know, Your Honor.
Right. See how easy that is? You come to me saying you can get $1,000 and you're dependent in your mind on somebody else to give you the two. So when do you think, because you're working part-time, I know FICA comes to you when you work part-time, as FICA comes to everybody. You're like, who's this FICA person? But they're always there with their hands up before you even see anything. So when do you think you can have $1,000?
I don't know.
You want to,
Do you think you can have it by, let's say, 4 weeks from now?
4 weeks from now, I'll get a job probably.
you think so? I mean, they're hiring at McDonald's and everywhere.
Yeah, or yeah. Or maybe KFC's.
All right. So don't burn the chicken and change the oil. All right. Miss Ferguson, can I have a 30-day reset? September 18th? All right, so September 18th. And if for some reason you can't come in with $1,000, you need to come in with at least 800 because that person wants their money, you understand?
So,
And I don't know how they do different places now, but I remember when I was working, Vashawn, the day I worked at Walmart, they always put my mother and my grandmother would always call it, you have to have a check in the hole before you even see your first check. So I don't know if they still do that now. I know with young people, somebody was telling me now they give you a credit card and put your check, put your pay on it.
Some places, yeah.
And then if you lose that card, then where are you? So you're going to have to start making some changes. And if you truly love your mom, then your behavior should show that. You understand?
understand, Your Honor.
All right. So we're going to bring you back on September 18th. You need to come with this money because that lady wants that money and can't be cash. State, you all don't take cash upstairs anymore
No,
with the cashiers.
It's either a money
Cashier.
order or a cashier's check.
Cashiers.
All right, so you need a money order or a cashier's check. And last time I checked, depending on the bank where you bank at, they're going to charge you a fee for that, or either they're going to charge you a fee for the money order wherever you go. All right,
It's 89 cents of what you do.
Okay.
there you go, HEB.
Thank you.
All right, thank you for dressing appropriately for court.
Thank you.
Thank you, Your Honor. May we be excused?
Yes, you may be excused. Good luck. All right, you two do better, okay? And get your education.
Yes.
Go get your, get your GED, do something.
I'll work on it.
All right. When you come back here, I want some plans from you too about your GED, or either you're doing some type of trade school. The days have gone by where you can say, I have a 9th grade education, let me go work at a plant job. Can't do that anymore. It's rare. Do you understand? All right, good luck to you. All right, who's the attorneys on Dinesha Walton? Hunter, I know it's you. Who's the defense attorney?
Fantastic question, Judge.
Let me- Yeah, let me find out who it is. All right, so would you like to join the Zoom? So I think Michael Bellevue is in breakout room number 1.
Okay.
And I think they're still getting paperwork together.
Would you like me to go upstairs, Judge, and get on Zoom or to the back?
Oh, you can go in the back, and Norma's in that room already, so maybe you can see what's happening with the paperwork.
Yes, ma'am.
All right, thank you. Here we are. Who is here on Tricia Harrison?
These are, yeah.
Yes,
Or maybe I had it wrong. I'm sorry.
Tricia. I have Tricia.
I had a middle name. I'm sorry.
No problem. Are you all proceeding on the motion to revoke?
We are, Your Honor.
Can I have a file stamp for a motion to revoke, please? Thank you. There you are. Court is calling 2024 CR 0452, State versus Tricia Harrison. Can I have the parties announced?
Megan Galloway for the state.
Brandon Lopez from Miss Harrison.
And are you Miss Harrison?
Yes, ma'am.
All right, Ms. Harrison, did you review the document entitled Motion to Revoke Community Supervision with your attorney? Did you understand it?
Yes, ma'am.
Are you the same Tricia Harrison who was placed on community supervision in 2024 CR 0452 for the offense of possession of a controlled substance, penalty group 1 less than 1 gram on July 23rd, 2024 for a term of 4 years? Is that you?
Yes, ma'am.
State?
Violation of condition number 4 in Bexar County, Texas. The defendant, Tricia Harrison, did then and there fail to report to the supervision officer as directed for the months of November and December 2024 in violation of condition number 4.
How do you plead to that? True or not true?
We waive and abandon the remainders, Your Honor.
Any objection?
No objection, Your Honor.
All right, did you understand by pleading true to violation of condition number 4, the court could find it true, grant the motion, and sentence you up to 2 years in the state jail facility and up to $1,000 fine?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition number 4?
Yes, ma'am.
Is there a proposed agreement?
Yes, Your Honor. It is to revoke the defendant's community supervision and sentence her to 8 months in the state jail facility.
That's our understanding, Your Honor.
All right, so why should I sentence her to 8 months as opposed to the 2 years?
Well, Your Honor, I do know that Miss Harrison was heavily involved in Esperanza Court, which is a very intense program. I believe the state and herself gave it the best shot they had. I know there were some complications with the pregnancy, which led to her cutting off of her monitor. She understands that that was an inappropriate, set of actions. She's here before the court, having made those efforts for several, I guess, almost 2 years, right?
Yes, sir.
Asking the court to give her the opportunity to move on by serving more time if she's not judgment satisfied yet, and just moving on, Your Honor.
All right, I'm not inclined to give her 8 months. I'm inclined to give her a year.
Would you give me a moment to speak to my client about?
Sure.
Your Honor, we're ready.
All right, yes.
She'll take the 12 months, Your Honor.
All right, are you waiving your right to appeal? All right. The court will sentence you to 1 year in the state jail facility, give you credit for any time served. The court will request the therapeutic community. There's $1,000 fine. Time and money will run concurrent. There's to be no unsupervised contact with minors. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it? All right, because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
8 months on the table, judge counters to 12, and defense recalibrates in real time. That's leverage, not chaos. The legal axis here is true to a single violation, failure to report, with the rest abandoned, tight, clean, and hard to fight later. But the human axis is heavier. Pregnancy complications, a cut ankle monitor, and a specialty court that still couldn't hold the line. Specialty dockets like Esperanza are intense, but they're not force fields against relapse or life shock. Judge Boyd's subtext is tough love. Programs help, only if you let them. Question: should cutting a monitor during a crisis escalate custody time or trigger more treatment instead?
All right, so my understanding, you were in Esperanza Court. I believe Esperanza Court reached out to probation to see what could be done. Here's the thing, nobody can help you if you don't want to get help. And sometimes when we're moving through life, guess what? The friends we had before, we have to cut them loose because we have to get ourselves together and work on being with our children. You understand?
Mhm.
All right, good luck to you. You're welcome.
Robert Ramirez from Miss Redwine, Your Honor.
And are you Miss Redwine?
Yes, ma'am.
Did you review the document entitled Motion to Revoke Community Supervision and First Amendment Motion to Revoke Community Supervision With your attorney, did you understand it? Ah, thank you.
Yes, ma'am.
Thank you, Miss Abrams. No. Yes. All right, we can go off the record. So what is the plan for Miss Redwine?
Your Honor, we were going to ask the court to alter and amend her conditions to add the moral recognition therapy course.
And then what's going to happen to these other cases?
I've not received all of the evidence from the arresting agency, and so at this point, I cannot make a representation to the court about that because our office has not received the cases.
Okay. Who is the alleged complainant?
If I can,
I can answer that, yeah.
Yes.
Joseph Friedman.
Joseph who?
Friedman.
You say Friedman?
Yes, Your Honor. Friedman. And he asked me to assist him in preparing an affidavit, not prosecution. That's been filed with the court, Your Honor. It speaks to all three of these allegations.
All right.
Judge, and if you could just give me a minute because there were some other individuals that were involved. A judge, so one more person would be a no contact order with an Andrew Garcia.
All right, this is what the court is going to do. The court has signed the motion to withdraw. The court is going to alter and amend conditions to include the MRT. There should be no contact with Joseph Friedman, Andrew Garcia, and no residing with the elderly.
Judge, and then there's one more person. It's a Jim Michael Ferguson.
And no contact with Jim Michael Ferguson. And so for the court, the elderly will be anyone over the age of 55. Thank you. I consider myself elderly.
Judge, the last name
It's Jim Michael Ferguson. And the other one is Andrew Garcia and Joseph Friedman, Freidman. Thank you.
Thank you, Your Honor.
You're welcome. Hi, how's it going? Questions in this case?
No, Your Honor. There's one case we're entering a plea on. He also has a motion to revoke.
All right, we'll start with the plea case. Court is calling 2025 CR 009122, State versus Joshua Robert Christian Craig.
It's Jerry McGee is my name. They had it on the paper.
All right, so we're gonna take care of that. All right, so the court is calling 2025 CR 009122, State versus Joshua Robert Christian Craig, aka Jerry McGee. Could I have parties announce?
Megan Galloway for the state.
David Andre Wood for Mr. McGee.
And are you Mr. McGee? All right, did you review the document entitled True Bill of Indictment with your attorney? Did you understand it?
Yes.
Counsel, do you waive the reading of the indictment?
I do, Judge.
State, are you proceeding on the indictment as presented?
Judge, is this the clause number ending in
22? It's the fraudulent use of possession of identifying information.
Judge, I believe they're proceeding on a lesser included
Yes.
offense that makes it a state jail felony.
That's correct, Your Honor.
All right. And counsel, have you received all discovery?
I have, Judge.
And did you review it with your client?
I did.
Court will find that the state is in compliance with discovery. Mr. McGee, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes.
Did you understand the state is proceeding on the lesser included offense of fraudulent use or possession of identifying information less than 5?
Yes, ma'am.
All right, that's a state jail felony. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses. The state will call in the right to remain silent. Did you understand by entering this plea, you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
He has, Judge.
Do you believe he has a rational as well as a factual understanding of the charges against him?
He does.
Do you believe he's currently competent and was legally sane at the time of the offense?
He is, Judge.
Mr. McGee, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, the state is proceeding on the lesser included offense of fraudulent use or possession of identifying items less than 5 items as a state jail felony. Punishment is to be assessed at 1 year in the state jail facility. There are no applications. This is to run concurrent with 2025 CR 000220 and 2025 CC 008696. The state will take in consideration 2025 CR 009123 and 2025 CR 009140. Did you understand that to be the plea?
Yes, ma'am.
Defense, is that the plea?
It is, Judge.
State, is that the plea?
It is, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, ma'am.
By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
No, Your Honor.
Then to the lesser included offense, how do you plead? Guilty, not guilty, or no contest?
No contest.
State, any evidence?
State offers states 1 in attachments.
Any
No
objections?
objections, Judge.
Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses? The state will call in the right to remain silent.
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court is going to accept into evidence States Exhibits 1 and attachments and review the same. After reviewing States Exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
We are, Judge.
Anything you wish to say on behalf of your client?
Just ask the court to follow the recommendation.
State, is there any restitution or no?
I don't believe so, Your Honor.
All right, the court will sentence you to 1 year in the state jail facility, give you credit for any time served. This will run concurrent with 2025 CR 000220, 2025 CC 008696. Take in consideration 2025 CR 009123, 2025 CR 009140, and there's to be no contact with Home Depot. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it?
Yes.
And did you sign it?
Yes, ma'am.
Because this is plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. We're proceeding with 2025 CR 000220. State versus Jerry Kyler McGee. Could I have parties announced, please?
Megan Galloway for the state.
David Andre Woodard for Mr. McGee.
And you're Mr. McGee?
Yes, ma'am.
All right, did you review the document entitled Motion to Revoke Community Supervision with your attorney? Did you understand it and did you sign it in all the appropriate places?
Yes, ma'am.
I'm sorry, not sign it, but did you review it?
Yes.
All right. Are you the same Jerry Kyler McGee who was placed on community supervision in 2025 CR 000220 for the offense of possession of a controlled substance penalty group 1, 4 to 200 grams on February 6, 2025 for a term of 8 years? Is that you?
Yes.
All right, state you may proceed.
Violation of condition number 4 in Bexar County, Texas. The defendant, Jerry Kyler McGee, did then and there fail to report to the supervision officer as directed for the months of March and April 2025 in violation of condition number 4.
How do you plead to that? True or not true?
True.
We waive and abandon the remainders, Your Honor.
Any objections to the waivers?
No, Your Honor.
Just give me one moment. It's just like old times. People are being requested to go into different breakout rooms.
Mhm.
All right. Did you understand by pleading true to violation of condition number 4, court could find it true, grant the motion, find you guilty, and sentence you up to 8 years in the prison?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition number 4?
Yes, ma'am.
Court will find violation of condition number 4 true. Is there a proposed agreement?
There is, Your Honor. It is to revoke the defendant's community supervision and sentence him to 5 years in the prison.
Is that correct, counsel?
It is, Judge.
Are you asking the court to follow that agreement? Sir,
Yes,
are you waiving your right to appeal?
Yes.
All right, the court will follow the agreement, sentence you to 5 years in the prison, give you credit for any time served. This is to run concurrent with 2025 CR 009122. There's to be no contact with the following persons: Savannah Lee, Devin Sanchez Martinez, and there's to be no residing with minors. And no unsupervised contact with minors. All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, ma'am.
All right, because this is plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is.
Watch the two-track collapse. A lesser included plea in one case, then a revocation in another, stacked into concurrent time. On paper, concurrency is mercy. In practice, it's a stopwatch ticking through multiple harms at once. Also note the no-contact web, named individuals, minors, even a retail ban, Home Depot. Courts use these orders like guardrails on a cliff road. Violate one and the next hearing isn't a conversation. It's a number. The judge's warning about losing half your life to prison churn? That's not rhetoric. It's the math of revocations, technicals, and fresh charges compounding. What would actually bend this curve? Longer sentences or longer supervision with treatment teeth?
You'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, you're gonna have to, we're gonna go off the record. You're gonna have to do better in your life. How old are you?
About to be 34.
You're gonna wake up if you continue on this path, and half of your life is going to be gone because you're gonna spend a majority of it in and out of someone's prison. Do you understand?
Yes, ma'am.
So do your best to do right.
Thank you.
All right, good luck to you.
Thanks. Fine.
Yes, that's yours. Okay.
So we need to go to the alternate first.
All right, I'm just gonna put you all in the same room. Are you on Cortez as well?
Yes.
Okay. Are you all ready to proceed on the motion to revoke?
Judge.
All right, the court is calling 2022 CR 6213, State versus Justin James Gonzalez. Could I have parties announced?
Rick Pena for the state of Texas.
Orlando Castanon for defense.
All right, and are you Mr. Gonzalez?
Yes.
Did you review the document entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision with your attorney? Did you understand it?
And Judge, just for the record, I was assigned today. I've discussed that he does have a right to preparation time. He wants to move forward today.
Is that correct, sir?
Yes.
And do you understand that your attorney has time to prepare for this case? Do you understand?
Yes.
And so if you would like for this case to be recalled so that he can have more time to prepare, the court will give you a reset. Do you understand?
Yes.
Do you want to have a reset for more time for your attorney to prepare? Or do you wish to proceed?
I would like more time.
Okay. All righty.
You let me know that an hour ago.
All right.
Okay.
Is this going to be a contested hearing?
I don't believe so, but there's some information that might be helpful for me to obtain.
All right. So how long, what type of setting do you want?
I guess just 10 days.
All right, Ms. Ferguson, if I can have a 10-day reset on Mr. Gonzalez, please.
Yes, ma'am.
Orlando, you were like, if only I would have known beforehand.
Yeah.
August 28th, is that good for you?
Works for you.
All right, so we'll be back on August 28th. He's not driving? All right, so what is happening with this case, Mr. Behrens?
Okay, Judge, a long time ago, we had got on to represent Mr. Cortez. That was in, I think, spring of 2019. In October of 2019, you appointed Armando Martinez to do an immigration evaluation under Padilla. According to Mr. Cortez Jimenez, that never really happened. He spoke with Mr. Martinez briefly, but there was never anything after that. So that still needs to get done. And I'm concerned about it because this is an evading detention with a vehicle, and which other attorneys I know tell me can be considered aggravated felony under the INS code. So,
yeah, so I think that person was appointed through the MAC, but we're going to see if the MAC can't do it, we can have someone else do it.
Yeah, FYI, I did send it in for another referral today while we were in court online with the MAC, and waiting to hear back. But if you can get something done sooner, I'm sure Mr. Cortez Jimenez would appreciate that.
All right, do you want someone appointed, a private person appointed?
I want whatever works quickest.
All right, Ms. Ferguson?
Yes, ma'am.
If you'll call Mr. Behrens and see if he has any objection to the private person who can take care of the immigration issue. All right, so Norma's going to call you with some names and then you just let us know.
Sure.
And then, sir, we're going to call you back. Norma, we're going to put it at a 30-day setting, but if you have the information before then, just let us know.
Okay. Yeah, because they're offering them deferred, but again, I just don't want to take any chances.
All right, Ms. Ferguson, could I have a 30-day reset? All right, so we're going to bring you back on September 18th, but we'll make sure that an immigration attorney is appointed to represent you.
And
for your immigration as it relates to the finding the case. They're not your immigration attorneys outside of this criminal case. Do you understand?
Si me puedes decir en español.
All right, if you can let him know that the immigration attorney who's appointed to represent him is only representing him as it relates to any outcomes this case will have on his immigration status.
Yeah, and they can call me and I'll explain what's the situation.
All right, thank you. Yes.
¿Puedo cambiar de abogado?
All right, thank you, Mr. Behrens.
Today's docket felt like a civics lesson with consequences. Pleas engineered for certainty, restitution as reality therapy, specialty courts trying to outpace chaos, and revocations reminding everyone that probation isn't a trophy. It's a treadmill. Legally, we saw clean records, rights waived on the record, discovery confirmed, stipulations replacing live testimony, and carefully tailored no-contact orders. Morally, it's messier. accountability versus capacity, protection versus second chances, closure versus the lifetime echo of labels. If you were on that bench for one day, where would you draw the line? More program time or more prison time? If this hearing hit you like it hit us, smash like, comment your verdict, and subscribe for weekly courtroom breakdowns. Your take might be featured next episode.